Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello folks, we're back today again talking about the Banc review for Brendan Dassey and his habeas relief. We're back here today to talk about the second half of Miss Nyrider's interaction with the judges of the panel of the Seventh Circuit Court. So this time we're going to get into more of the questions, basically with, Miss Nyrider talking to, Hamilton, Can, and obviously with Judges Robner and Wood and Williams also chiming in at certain points. So we're going to go over today the second half of Miss Nyrider's oral argument, and we're going to discuss it a little bit.
The state of Wisconsin views this confession as corroborated, but in fact the corroboration on which it hangs its hat was a product also of the fact feeding that occurred during this interrogation. They point to the bullet found in the garage, but it was the interrogators themselves who took Brendan Dassey into that garage. Originally, he had the shooting occurring outside the garage, near the bonfire pit, and it is them who say, Brendan, we need to get the accuracy about the garage. Why do they think it happened in the garage? Because they had previously found shell casings in that garage.
The motive of the police was to get a second killer?
I'm sorry, Your Honor?
What was the motive of the police in doing this? Get a second killer?
Your Honor, the test does not direct us.
No, I know that's not the test. That's the question I'm asking you.
The record doesn't speak to the motive of the police in this case.
You're arguing their motive.
I am not, Your Honor. In fact, the district court here, in granting relief, pointed out that the police may well have simply failed to appreciate the way in which their words landed on Brendan Dassey. And that may well be the case in this case, but it does not preclude relief. In fact, it still bolsters relief under the principles of Miller versus Fenton.
So they needed two killers.
This bit where Judge Can is asking about why did they do this? Did they needed two killers? What he's getting at is he's saying that Miss Nyrider is suggesting that they were consciously coercing Brendan. And that why would they do that? Because they needed two killers. Well, what he's getting at is what would be the police's motive, or the law enforcement's motive for doing that. Well, we know, and I don't know if Can knows or not, but we know that it's because they knew that the evidence wasn't really coming in against Stephen like they wanted, and they wanted to get Brendan, on record and be able to use his confession against Stephen, or at least by getting Brendan to confess the way they did, they were able to get back onto the property and were able to find this other evidence, the magic bullet, the hood latch DNA, which looks like it was clearly swapped with a buccal swab full of Stephen's DNA. I mean, so apparently Judge Can doesn't know about this, or he's just being thorough. So whatever the case may be, that's what he's getting at here. I know it sounds a little odd the way he's saying it, but that's what he's getting at.
No, Your Honor, they needed the truth. But the problem with this interrogation is that the way in which they pressured and pursued Brendan Dassey was in direct contravention of the seeking of the truth. That's the problem here. They may have failed to appreciate it at the time, but that is not the relevant inquiry.
And now we're going to hear Mrs. Nyrider talk about Brendan's limitations, and she's even going to talk about how these investigators easily, when they were picking Brendan up from school on March 1st, had already interviewed Brendan on the 27th, had spent the weekend with him and his family at the Fox Hills Resort. On Monday morning, when they were at that school, they should have had some inkling, and they could have easily asked the counselor for a file on Brendan and see what was there, just so that they could cover their bases. But they didn't do that. They didn't want to do that, because they knew if they asked for it, they knew there was probably going to be something, and they wanted to go on as if they wanted to continue on as if if they don't see it, it doesn't exist kind of thing. And so they didn't want to ask about anything like that because they didn't want anything like that to turn up that would have thrown a monkey wrench into their plan. So that's basically what she's getting at here.
They knew that he was 16 years old, Your Honor, and in the 10th grade. They picked him up twice from his school and had previous interactions with a school counselor, at which they could well have asked for Brendan Dassey's records, his extensive IEPs, and other special education records. But they had enough information to know that he was limited, and especially on March 1st, they should have known when they asked Brendan Dassey to produce the one piece of non-public information about this crime, that the true perpetrator should have known that she was shot in the head. And he responded by guessing with all these various different theories about how the murder happened, trying to inculpate himself in a murder, but not knowing how to describe the murder he supposedly committed. If this court does not measure the words said to Brendan by Brendan's ability to withstand them, then Miller versus Fenton has no meaning when it tells us that the voluntariness inquiry applies equally to cases in which the tactics are coercive only as applied to the unique characteristics of the particular suspect.
So, as Miss Nyrider was saying right there, as you were just hearing at the end of that clip, this comes down to the fact that this is a very unique situation with a very unique defendant with a very unique disability, and that disability caused him to hear that promise, and that promise was a bargain for him. Now, what she's also saying is that these cases, you know, with these kind of individuals like Brendan, people who require such special care, they have to be given the special care. The special care is absolutely paramount. And so that's the main takeaway from all of this, in my opinion. The main takeaway here is, unlike what Brad Schimmel would try to have you believe, this does not apply across the board. This does not work for just anybody, this defense that they're presenting for Brendan here on habeas. It wouldn't work for just anybody, because it just wouldn't. A normal functioning adult, for instance, would not be able to use this case law. And you know, that's basically what it comes down to. This does not go across the board as Brad Schimmel seems to think it would. This is for a very select few people moving forward in the future who have the similar characteristics to this case, to Brendan, to the investigators, that will be able to use this case law. It's not going to be changing anywhere near as much as Brad Schimmel in the state of Wisconsin would have you believe. After listening to all of Miss Nyrider's segment, I mean, I think she really did a tremendous job. I think she really knocked it out of the park. She was very, very well, she very well illustrated exactly the points that she was trying to make, particularly when it came to Brendan and how he understood that idiom and how he really took it as a bargain. And that when that bargain was broken, that's when he was asking for his mom, and that's when he was starting to cry, because suddenly what he thought was an understanding between him and the investigators was now gone. He was now desolate, going to prison, in huge trouble, and all he had been trying to do was please the investigators to begin with. So I think it's pretty clear, but I think she was able to illustrate exactly the way he broke down at that moment, because the bargain was broken, was very powerful the way that she managed to illustrate that. So that's about it for Laura's segment, her interaction with the judges. We're going to be doing one more segment about the on-bank review, and that's going to be Mr. Luke Berg's final closing up. So if you haven't already, please hit subscribe, and see ya.